plaintiff's counsel.
Yes, Your Honor, Michael Berg Simpson, appearing on behalf of the plaintiffs.
And we have counsel for the state defendants.
Yes, Your Honor. Ravi Patel and Georgia Staten appearing on behalf of the state defendants.
Do we have any other? I don't think we do have any other appearances.
I don't know if you want observers to make appearances, Judge.
Well, why don't we have everybody who's, when you say observers, are you talking about co-counsel or?
Co-counsel, yes.
I don't think that's necessary if you're not arguing. So we're here for oral argument today on the state defendant's motion to dismiss in the case. I've reviewed the complaint, the parties briefing, the authorities that you've cited, and the exhibits that were attached to the parties briefing. So I wanted to just start, so I don't have to interrupt you too much, by telling you that I'd like you to focus first on the administrative exhaustion issue. In particular, the thing I'm struggling with is whether any of the claims asserted can be adjudicated without determining the validity of the payment denial, suspension, exclusion, or termination. And if so, what specific parties and claims can be decided outside of those issues or decisions? And then second to that, the notice of claim issue. I know there's a dispute on which version of the chart was served and the legible version, which as opposed to the version that was attached to the response to the motion. And I will tell you that I don't think that's a determination I can make when it's disputed on the pleadings. And so I'm going to assume for purposes of this motion that the version that was served was the version attached to the response. And if that's the version, how does that impact the notice of claim argument? Or if I can't make that determination or make that assumption for purposes of this motion, then do we have to have some sort of expedited trial on that issue under subsection G? And then finally, I'd like you, to the extent you have time, to talk about immunity. But primarily, I want your focus to be on exhaustion, because I think that's the principal legal issue. And obviously, this is a very complex case with lots of different parties and claims. So I want to give you the opportunity to talk about that issue as it applies to all of the various parties and claims that are at issue in the case. So this is your motion. And I don't know who's arguing today for the defendants.
Mr. Patel will be arguing, Your Honor.
All right, whenever you're ready.
Thank you, Your Honor. We think that the exhaustion argument really goes to the heart of all of plaintiff's claims. All of plaintiff's claims are predicated on the notion that the underlying suspensions, terminations, exclusions, the claims denials, or what they call the slow pay, all of those things are at the heart of plaintiff's claims, and they're all subject to the exhaustion requirement. None of plaintiff's claims really address any issue that isn't predicated on the idea that they were somehow wrongfully suspended or wrongfully terminated, or that they were entitled to the payment of claims that they did not receive. So I think that is really dispositive of all of plaintiff's claims. And the exhaustion requirement is statutory, and the courts have been very clear that this covers all claims, and we cited the St. Mary's Hospital case that made it very clear that all claims for unreimbursed medical services must be presented to and determined by AXIS, must go through this process. And if there are other claims, as plaintiffs have brought, and St. Mary's dealt with similar issues of defamation claims or intentional infliction claims, all of these other claims, even plaintiff's discrimination claims, all of those things are inextricably intertwined with the issue as to whether Axis appropriately, found that there were credible allegations of fraud, took these suspensions or denied claims. And these are technical issues, right? Whether a claim is a clean claim, which underlies, for instance, plaintiff's negligence per se claim, is something that is best determined at the administrative level with the benefit of the Office of Administrative Hearings experience with dealing with these sorts of claims, with Axis's review internally. And then once you get through the administrative hearing process and get through a director's decision, then through the Administrative Review Act, then it gets to the court. And in fact, one of the plaintiffs, Sondercare, did that. They walked through the process all the way through the Superior Court. Now, they weren't successful at the Superior Court level, and they chose not to appeal that decision. But it's a process was available to each of the plaintiffs, and forms the underlying basis for any claim. It rolls it up. Plaintiffs make the argument that pursuing these remedies would be futile. And that's simply not the case. Arizona law requires that plaintiffs prove, in order to prove futility, that there is no relief that could be had through the administrative process. And they haven't alleged that, and they haven't met their burden for that. Their idea that there's structural issues because it ultimately goes to a director's decision before it goes to the Superior Court also doesn't really hold water. We cited cases from the Supreme Court and others showing that due process supports an administrative review where an agency has this review. Plus, at the end of the day, it comes back to the Superior Court. The Administrative Review Act provides a judicial review that follows the administrative review. So that's really the appropriate process that needs to be followed here. And that precludes and really deprives the court of jurisdiction over all plaintiffs' claims until they first show that there's some sort of improper or get some sort of reversal of Axis's actions. So that's our view of exhaustion. That we feel fully dispositive of the complaint at this stage. If the court dismisses this, there are some plaintiffs who have pending administrative procedures that are stayed right now that can pick up and go on. I don't think that's true of all of the plaintiffs. Some of them either didn't appeal or didn't appeal everything. But at any rate, they have the ability to do so. Your Honor, do you have any questions on that before I move on to the notice of claim issue?
No.
Okay. As to the notice of claim issues, leaving apart the issue of the versions of the exhibit, there's a timeliness issue that underlies pretty much every plaintiff's claim that's a notice of claim defect. And we provided in our motion on page 19 and 20 a chart that walks through both the notice of claim and statute of limitations issues. And the notice of claim issues bar all but I think one of plaintiff's claims. So the Akowuahs and Richland Regal, they timely filed their notice of claim. Most of Camelback Recovery and Treatment Center's claims would be barred by failure to timely serve a notice of claim. The only one that could be timely is their claim regarding the August 26, 2024 notice of termination and exclusion. If the court found that that was not subject to the administrative exhaustion requirement. And keep in mind, Your Honor, that our position on the notice of claim is contingent on the court finding that the administrative remedy process is not mandatory. Of course, if it is mandatory, then there's tolling under the statute. But if it's not mandatory and the court can address that issue of notice of claim here, it bars the claims of the Akowuahs and Richland Regal. It bars the claims of Solus Behavioral Health, Sonder Care, and its owners. Those claims are additionally barred by res judicata because, again, when appealed, the underlying suspensions were upheld. It bars the claims for Core Health Services and Kathy Wiggins. Kathy Wiggins had an additional argument that they had sent an earlier demand letter that they characterized as a notice of claim, but that didn't have a some certain demand, and so that didn't comply with the notice of claim requirement. The Saving Lives and Linda Watson, again, were notice of claim was served more than a year after their first notice of suspension, and 7 months after the notice of claim period expired for their November of 2023 notice of termination and exclusion. And then Fast Care, Omar Fadlala and Ali Al Khoury, again, filed one notice of claim more than a year after the 180 days had passed, and more than 4 months after their claim that they had received no payment since January of 2024. So really, with the exception of one potential claim from Camelback Recovery and Treatment Center, all of plaintiffs' claims would be barred for failure just to timely serve a notice of claim. And then there are also other issues with respect to the notice of claim. For instance, the notice of claims don't properly preserve claims against directors Ferretti and Cunico. And they can't be really sued in their official capacities as plaintiffs have named them anyway, because, and this overlaps with the immunity arguments, but ARS 41621K holds that they're not liable for any claims of damages arising out of their official capacity. And so at best, those claims would be duplicative of claims against the state. But they also just weren't preserved in the notices of claim because they weren't named and properly served with a notice of claim as to that, as opposed to their agencies. Do you have any questions about that before I move on to immunity, Your Honor?
I don't.
Okay. With respect to immunity, there's different immunity arguments that apply to different parts of plaintiff's claims. Particularly, plaintiff's negligent claims significantly arise out of a failure to fund, staff, and train employees. And all of those claims are barred by absolute immunity. ARS 82001A provides absolute immunity arising from the exercise of an administrative function involving the determination of fundamental governmental policy, which expressly includes the hiring of personnel, provision of resources, and the determination on how to spend resources, including those allocated for equipment, facilities, personnel. These decisions broadly, as well as enacting sweeping policies, as plaintiffs alleged, as to how you're enforcing anti-fraud efforts or how you're making claims policies, these policy-making functions are all protected under absolute immunity under the statute. These aren't individual tactical things as plaintiffs have alleged them. With respect to plaintiffs' negligent investigation type claims, those claims, which is really the other category of claims that plaintiffs make, even though they're framed in different ways through the various counts of the complaint, for those claims, the state would be entitled to qualified immunity. So plaintiff would have to prove gross negligence. which means they have to prove willful and wanton conduct, with a reckless indifference to the rights of the various plaintiffs. And they simply haven't pled anything like that in the complaint. The complaint indicates that the plaintiffs disagree with the basis for their suspensions, disagree with the various claims decisions that Axis made, but they don't allege that any state or state actor had some sort of animus that drove these decisions.
But the reckless standard under Spooner doesn't really require animus, does it? I mean, and they do allege that the investigations, I mean, I have to assume all the facts are true and all reasonable inferences that I draw have to be in plaintiff's favor at this stage. Can I really grant dismissal on the pleadings on the investigation claims?
Well, again, they have to prove, perhaps animus is not the right word, but they do have to prove some sort of willful conduct to get to gross negligence. And they haven't alleged that. They haven't alleged really any specific investigator acted with that sort of recklessness. Their allegations are kind of directed broadly towards the agencies, but they don't allege well-pled facts that support a gross negligence claim. And Your Honor, these immunity issues, while I talked about them in the context of the negligence claim, because I think that's where they apply most easily, they also apply to plaintiffs' other claims. If the state is immune under Spooner, they'd be immune from, the other claims for breach of the implied covenant, tortious interference, intentional infliction of emotional distress, those things, and of course, vicarious liability is just a add-on claim because they don't allege any acts by or any claims against any individuals except the agency directors. Your Honor, with respect to immunity, that's really all I have to say. In my view, the exhaustion and the notice of claim issues really address the vast majority of plaintiffs' claims in the alternative. I'd be happy to talk about some of the other claims that plaintiffs raise on a point-by-point basis, but I think you've read through the motions fairly well, and we've briefed that out. So if the court doesn't have questions there, I'll reserve my time.
All right. Thank you, Mr. Patel. Mr. Burke?
Thank you, Your Honor. First of all, I want to thank you for reading all the papers on this complex case. Let's start out with the immunity. Let's start out with the exhaustion of administrative remedies. First of all, in reading the St. Mary's case, that case is about a dispute over payment. It is not for what happened in this case. And while counsel says we didn't specifically talk about the fact that they willfully, wantonly, recklessly did or failed to do any investigation. And the bottom line is many of these companies are out of business. This, as we described in our complaint, this systematic attack on, quite frankly, most of these are minority-owned entities that enter into a contract with the state. There is very little doubt that these people were authorized pursuant to the contract to do and provide services as stated in the contract. Starting in 2022, we have alleged that there was a systematic attack on these minorities, and they took, and I thank you, Your Honor, you have to look at our pleadings in the best light at this stage of the proceeding under Rule 12. So what happened here is they began to terminate these people threatened them with fraud, threatened them that they were going to have to pay back millions of dollars. And quite frankly, they never had the investigation revealed to anyone that gave forth to these allegations. So our clients, many of them attempted to comply with the administrative remedy, and every time they began to apply, they would be told, oh, okay, but what about this? Something different. We're now into 2026. And like I said, many of these companies are out of business. They've had their homes foreclosed. They've had, debts piling up because they've been embroiled in this system where, quite frankly, they had an inability to comply, and to comply would be futile. This is the perfect situation where futility is here.
But how can you really argue futility as a whole when there was some relief with respect to certain of these claims by taking advantage of the administrative process? I think, and I'm not sure, I can't remember exactly which one, but one suspension was rescinded.
Right.
There was a settlement concerning the termination notices. So that suggests that's a hard argument to make. It's hard to say futility when there are certain instances where taking advantage of the process resulted in relief being available.
Your Honor, when you say relief, it's not really relief. It may be an emotional relief that they're not going to go after them for $5 million or prosecute them criminally for fraud. I mean, these people were desperate as to try to get out from under the thumb of what these accusations are. I'd like to just point out a couple of things that shows where the defense is going. In their reply brief on page 2, in the paragraph next to the last paragraph, they say, regardless of whether plaintiff can prove the decisions were part of a systematic attack, the first question is whether access actions were proper application of the applicable Medicare and access statutes, regulations, policies, and procedures. We're here to get the opportunity to do the discovery, to find out. Counsel says, we didn't make specific allegations concerning, and I want to use his quotes, recklessness, willful and wanton conduct, but we haven't had that opportunity to do that. Yes, we believe from the actions taken by the defendants here, this was a concerted action by the state to wipe out all of these people with threats of fraud, that they're going to go after them for millions of dollars, that they stop payments to them prior to even saying what the problem was. And so we believe, and Your Honor, you're right. Some of these people said, I want to play or try to play within the system to see if I can get relief. But the reality is that the system is rigged, and these people did not get an opportunity to go through it because it was futile. And I understand this is, and again, I think you would distinguish the St. Mary case, which was only about payments. And that makes sense. It makes sense when you're talking about, should they have been paid? Did they meet the requirements under the statutes? Did they meet the access requirements? Should they have gotten paid? And it's interesting, of course, even in that case, the Court of Appeals agreed with the Superior Court by saying it was dismissed without prejudice, giving them an opportunity to continue on to seek the evidence and go forward to the director to see if they could get some sort of result. Here, and in one of the other cases, and I don't have the site in front of me right now, they talked about an alleged wrong. Well, here, what is the alleged wrong? Here, these people are out of business. And we're going to be in a situation, if you dismiss all these claims, then these people, they're out of luck because they're not going to be able to go and do the discovery, which this system, you know, I've been doing this for 50 years. I guess I don't know if that's a good thing or a bad thing. But the one thing I love about the system is that we're afforded an opportunity to do the discovery, to take depositions of these people. And we're here to ask for that, whether it's on just those claims, the negligent infliction of emotional distress, or whether it's on the additional claims that come under that counsel talked about. And they, many times in their briefs, I think, here, for example, the plaintiffs overlook they cannot win their claims without proving, this is on page 3 of the reply, that access actions were unjustified. They recognize that if you throw this out in total, that we won't have the opportunity to prove that their actions were unjustified or that they were, they had as we said in their reply, the systematic attack. And so I do believe under these facts, looking at our pleading in its best light, that futility here does apply. And I think, and we've asked the court to apply it. I think I sort of already talked about the third issue here on the immunity. These qualified immunities that they're talking about on these claims do not create a complete bar to us going forward with those claims so that we can take the depositions, so we can find out and get the notes and see what the purpose was. Because this was not, and this is important, Your Honor, and I know you know that, and I appreciate your diligence in reading everything. This is not just one of these entities that were under attack. It was all of them. It was all of them, primarily minorities. But they decided we're going to get rid of all these people and we're going to get rid of them. And we're going to, I mean, it's clearer from the pleadings and from the briefing that they were, and yeah, did they say, I mean, think about it. You're going to have to pay us back $5 million. And these people are saying, I don't have $5 million. And then the people come forward and they say, okay, we're going to withdraw the claim that you have to pay us back. And then the same thing with suspensions and termination. We have one issue here where they withdrew the suspension and then they, months later, renewed the suspension. And so in the effort with regard to having this actually finding out, and look, if we do the depositions and we don't have a case, then they can file a motion for summary judgment. That would be the proper place for this, not at this stage of the proceeding. If there are no factual issues in dispute and we don't have a case, then this case will go away. But they are very, very, one other thing I would say, and I don't know if you'll find it humorous or not, but their brief is a shotgun. It's a shotgun. They're pulling everything they can because they know they don't have a rifle. They even used Rule 8 as their lead argument in this. And I think that's very telling, that they're very concerned that if we get to do discovery in this case on whatever claims that you believe should exist and go forward, then I think we then get our due process.
What about the argument on what about the argument on absolute immunity for staffing, hiring, policy decisions, that sort of separating out the investigation, the claims based on an investigation?
I would think they do have complete immunity on that based on the case law and based on the statutes. So we agree with that, Your Honor.
Okay. I apologize. Go ahead. I've interrupted you a lot.
No. I don't want to interrupt you, Your Honor. All I'm saying is, do you have any other questions? I think between the briefing and what I've talked about in the oral arguments and those things that you can see in the briefing of the facts that occurred here, I do think that with regard to those claims that they have only a qualified immunity, we certainly should move forward with those. And I do think if there ever was a case for futility, it would be this one.
All right. Thank you, Mr. Burke. Mr. Patel, any rebuttal?
Yes, Your Honor, thank you. Well, I think you've heard kind of a closing argument from plaintiff's counsel here, but an emotional response doesn't really address the legal questions. You know, he threw out terms like a systemic attack, said that the plaintiffs went out of business, said the system was rigged, but there's no well-pled allegation showing that the system is rigged. Plaintiffs want to put the cart before the horse before they can show that there's any sort of improper activity. They have to show ultimately what the administrative process would shake out if they have appealed, which is whether the denials, whether the suspensions, whether the terminations were appropriate or not. That's the avenue that the legislature has set forth to make that determination in the first place. In the context of that, if they want to make the argument that that this was part of a systemic attack, that's certainly not how they characterized in the reply. On page 5 of the reply, plaintiffs say that defendants initiated a broad enforcement effort aimed at addressing fraud within the behavioral health system, which I think we can all agree is an important goal. They also say that defendants implemented sweeping operational changes affecting claims processing and provider interaction. These allegations don't show a targeting of minorities. And by the way, nowhere in the complaint does plaintiff allege the race of any of the various plaintiffs who brought suit. That allegation isn't there for their discrimination claim. That they haven't supported showing that they're a member of a protected class, let alone that they were targeted because they were a member of a protected class. They try to make some general allegations about it, but there's no well-pled factual allegations of information that could be